Hey, Alex, a lawyer and a financial advisor walk into a bar, and we've got a special guest. Hang on, Alex, you've jumped the gun there. We've got a special guest with us today. Pat Mannix.
Exciting.
So we have a lawyer, a financial advisor, and an accountant. I can hear the clapping in the background from the audience. My God, this is three of the best-looking blokes you've ever seen. So the topic we're going to pick up today, structural risks. What's the best entity to operate from?
Sorry, mate. I'm cutting in all the time. It's a recipe for any excitement, isn't it? Lawyer, financial planner, and an accountant.
Yeah, I know. It sounds like a joke, doesn't it, at the beginning of a joke?
Yeah.
So, Pat, thanks for coming on. We appreciate having you here. You're the tax champion from Paris Financial and know about all things structuring and risk. And so why don't you just tell us a little bit about yourself?
Yeah, definitely, Alex. Yeah, I've been in tax shivers for over 30 years now and still love it. And especially as you guys have mentioned, the structuring side of tax and getting that right, especially for growing small businesses and investors. So followed my dad into the business. He started in the late 70s and I joined him obviously a bit over 30 years ago and have been whacking away ever since, and spent a lot of my time obviously with our own people, helping to guide them and with clients on structuring, for asset protection and that sort of thing.
Yeah, well, because one of the questions I get all the time, and I'm sure all of us get, and we really want your expertise on it, is what's the right structure for my business? What's the ultimate structure that I should have when I'm running a business? Should I be a sole trader? Should I be a company? Should I be a trust, a trading trust? There's so many different structures around. What's the right one for me? How do you answer that question?
Yeah, so it depends. If a person is starting out in business, they're not sure how they're going to go. Perhaps they don't have a huge amount of business risk. They mightn't be turning over too much. We just try to keep it very, very simple, where they can open up a bank account, get a business name of ASIC for $40 and just starting a business under their own name. But once any sort of client gets their turnover, profit, etc., up above $200,000-300,000 in particular profit, we make sure that they'll be restructured under either a company, a trading trust, as you've mentioned, or a unit trust. It depends on the business. It depends what industry they're in. But the first thing we're going to say to them is, once you get to that level, you need to set up for asset protection and security first. So Pat, can I just jump in on there? It was an interesting point that you've made before. You sort of said when they get up to $200,000 to $300,000 profit. So are you saying that the suggestion on the different sort of structure will vary? Is it profit or turnover? Yeah, no, definitely it's profit, because you got a lot of businesses out there could turn over $200,000 to $300,000 and make next to no profit.
Yep.
And the business risk potentially could be very low. A lot of business fall over in the first 5 years, and so to sit down with a client like that and say, look, we want you to set up in a trading trust with a trustee company, and this happens and that happens, and you'll save tax here, but it'll cost you $4,000. It's too much for them from a cost point of view, too much complexity, and there's just not enough benefit in it. We always make them aware of the potential legalities of running the business under their own name. But so really, Dave, they've got to have $150,000 to $200,000 in profit to then have that conversation. Then they're starting to have a business with potential, risk to creditors, to lawsuits, all that sort of thing. That's the number one thing, to make sure when they've got a decent amount of profit, they're structured correctly for asset protection. And then we obviously have tax in mind as well when we're doing that.
So when we go back to this, I suppose the basic question that Alex has sort of raised, because the topic that we're covering in our discussion today is, the structural risks. What are the best entities to operate from? If we go back to the basics, what are the different structures that people can operate a business in?
Yeah, so the businesses can operate under their own name, which is a sole trader. They can operate under a common law partnership with their personal partner or a business partner. They can operate as a trading trust, which is generally for one family under a family discretionary trust. And we would always recommend a trustee company to give them some asset protection to run that trust. If they have a business partner who's not in their family, they can run under a unit trust. And then the final one is a trading company. So they're all the structures that a business can run under.
And so would businesses cascade through some of those structures, or does it depend upon, the success that they believe the company or the business is going to operate from immediately?
That's a good question, Dave. They would go from one structure to another, depending on what I said earlier, cost, asset protection, etc. And if that's done right at the right time, that's it. But what we do a lot at Paris Financial is we've got to restructure people because they're in the wrong structure when they come to us for asset protection, and that flows on to their tax as well.
Yeah, and can I say we see that all the time. Clients come to us. We're not specifically into structuring, but we see clients come to us who are badly structured, and it creates legal risk for them all the time. They say, "Okay, well, I'm invested in this property development company, in this property development project through my family trust, and I'm also that trust, the trustee of that trust is also operating a business." And that business is risky. And we just had one recently who was, in exactly that position where the property development project was going badly, and that was putting the business at risk, right? Because the business assets and the property development project were all owned by the same entity when they should have been separated out. You should have had one entity for the business and another entity for the property development project. Putting them together was madness, and it was really, I think, it was just poor planning. So restructuring that prior to them having this liability would have been a good idea.
Which goes back to the contamination issue. It's a bit like when people borrow proceeds to invest in a business, but then they also draw on that same borrowing facility for personal use, but then they're trying to claim all of the interest expense, and it's like, but is the borrowed funds used to generate an income, or is the borrowing used for some personal assets? And to me, that's the same thing, and which probably goes back to the point in a lot of circumstances when we talk about structural risk. What's the best entity to operate from? Seek advice. Like, go and ask your accountant, this is what I'm thinking of doing. Do this before you actually execute the deal. And sometimes it can be just a quick phone call, and other times it may be appropriate that they come down and sit, preferably not a lawyer in some respects, in that you generally will come and see Alex when there's an issue, as opposed to seeing Pat or myself in the early stages around how should we look to set that sort of stuff up. Yeah. Because you do see it. People go, oh, my God, I should have, could have, would have. Yes, you should have.
You're spot on, David. Look, our best clients, they do that. It's actually not that expensive. They get structured right. And our best clients, I get about 3 phone calls a year. Listen, I'm looking at buying this, but what structure do we use? It's not another property. Oh, let's look at the land tax, do the calcs, buy it in that. All done in about an hour. So you've nailed it. That we get a lot of clients like you guys that are cross-contaminated for various reasons. And if they structure correctly at the start and just call their accountant, when they need to, as I mentioned, it does keep it simple. When they don't get that advice and they just keep trundling along, they get into trouble. They've got to be restructured.
That's before they do that deal, or before they say, I'm looking at buying this bit of property. What structure should I do it in? And if they need to set up a new company, they can do it then, rather than I've signed the contract and I'm settling it next week. Okay. Pat, what about you see companies, a lot of businesses are companies, and a lot of businesses are trusts, right? Yeah. And in fact, there's obviously some businesses that have kind of both. You might have the shares in a company's shares owned by a trust. So what are the kind of advantages and disadvantages of a company versus a trust, which are probably the two most popular mechanisms?
That's an excellent question, and the world's changed around that. So late February 2022, the tax office put out a couple of rulings which has changed the answer to that question probably forever. So we would have, before that ruling came out, we would have tended to lean towards one family mum and dad or personal partners, to run the business under a trading trust, a trading discretionary trust. But the tax office rulings come out where, to be able to run with good working capital under that structure and not have issues underneath the trust, that's a problem now. It's too complicated. So we're leaning towards those growing small businesses just with one family to now run under a trading company with a discretionary trust owning the shares. So that's right. So the
whole structure on that has kind of changed. So you're now saying through that you operate your business out of the company, but your family trust that may have a corporate beneficiary is the owner of the shares.
Yeah, you hit the nail on the head, though. Yeah, hit the nail on the head. And that they popped that ruling out. I think it was about the 22nd of Feb 2022. And
is that because of the distribution issues?
Yeah, that's exactly right. There was distribution issues. So there was what's called sub-trust rules, which were really, really good within discretionary trusts, which they've essentially knocked out and has changed the way, you structure for asset protection and for growing small businesses with one family.
So I didn't think that had been passed. Has that been passed?
Yeah, look, it's a direction of the ATO, and it's pretty much passed, yes. So you're not really going to distribute to a sub-trust out of a family trust after the 1st of July 2022.
Oh, so you wouldn't distribute out to a corporate beneficiary, or you would?
No, you'd still distribute out to a corporate beneficiary, but not to a sub-trust. So they've essentially knocked the sub-trust rules on the head. Those sub-trust rules came out in sort of around about 2009. So they run for sort of 12 or 13 years. And they've just pretty much knocked those on the head, which is fine. But it just means that a growing small business should, that's making reasonable profit should run under a trading company with a family trust owning the shares.
Yeah, so they won't retrospectively look back?
No, they won't. They won't look back. No. It's from the 1st of July 2022 that new structuring goes from there. Yeah.
So is that the issue where sometimes individuals through their appropriate tax planning may decide to distribute to a child who is over 18 from a trust perspective? Is that the thing that they're trying to remove?
No. Well, again, Dave, it's a brilliant question because they put two rulings out. I think it was within the one day or one day after the other, and just went completely under the radar because they have for 120 odd years you've been able to, distribute to, an adult child, over 18. And, there was a bit of flexibility around that. All right. Now, once you distribute to that child, you've got to give them the dough, and really you've got to be pretty rigorous. You've got to be rigorous now with your living estate planning if you're going to do that.
Aren't we paying for them when they live at home and they get fed and watered?
It's not like you haven't paid them already. Yeah, that's right.
Yeah. You're just trying to recoup a bit of your expense along the way.
Well, my son Noah's 20, but the tax office might say, well, why are you paying him $150,000? Is he that expensive? And I can say, well, he wants to go to Hawaii every year.
Yeah, he's very expensive.
But it's that sort of thing. So look, it's still really there for people who want to do living estate planning, but I don't know whether a lot of people really want to do that. I think they want to kick the bucket and then they can fight over the money.
Well, see, but that's interesting because we're doing quite a lot of work in that intergenerational transfer stuff, and so this is I agree with you. Part of it is how do you cascade those assets down that continue to give you the risk management for yourself prior to your departure of this lovely world, versus just letting it continue along and then waiting for the estate to distribute it. Like, how do you, successfully work your way through? I just think all of that structuring can be quite interesting, and a lot of people are pushing back on that a bit.
No. That living estate planning, especially when people, successful business people get into their 40s and early 50s, they need to get that estate planning right. I mean, there's testamentary trusts, there's death benefit nominations within super.
Yep.
It's huge, and too many people just leave it. And even more so with what I just mentioned, Dave, about, distributions from discretionary trust, because they might have some kids where they do want to put some dough aside through their family trust, and maybe they don't want them to get their hands on it until they're sort of 25, 30, just in case one of them ends up a drug addict or, married to a dragon or that sort of thing.
Yeah, and you don't always want to deal with that in your will process. So you don't set up a testamentary trust. You want to kind of sometimes also work around how do you distribute through to family members that they have a capital pool, but there's restrictions that are placed around them accessing the corpus of proceeds, but they may receive the distribution as they get older, or it may get staggered over from 25 to 30 to 35, and then they may get ultimate control of that trust at 40 or something.
No, that's exactly right. And people need to put in a lot more time than they do. Don't wait till we're flying on a plane, so we better get our wheels organised.
Yeah. And by the way, I'm like, Pat, I'm leaving I'm on a 6 a.m. flight tomorrow, and I know it's 3:30 in the afternoon. Do you reckon we could get that sorted out this afternoon?
Yeah. That's right. Oh, exactly right, Dave. Or it might be, Jenny in her early 50s and her mate next door, Jill suddenly passed away or got cancer. And I've
been looking after her.
And get that done. Yeah, they really need proper legal advice there with a tax element as well, and asset protection. They need that and get that in place really into your 40s. Once you're making a few bucks in business, that living estate planning is vital.
Yeah. So Alex, we're just picking up on the topic of today of structural risk and what's the best entities to operate from. And Pat and I were just having a bit of a banter on a little bit of the living will kind of concept. How do you cascade it through, and should you be setting up different trust or looking at all of those risk management strategies for family members rather than giving them direct access to the proceeds, putting it into a structure that they can get access to either, a percentage of it or not the direct corpus, but it might be a progressive release, and you may feel confident in the distribution. They may get access from 25 and then 30 and then 35 and maybe full access from 40 onwards. So it's an interesting topic when we start to, because this is where it comes back to that early question around, we talk about the different structures being just a trading name, an own name, and then you'll talk about a family trust or a company structure. This is where the issue comes into horses for courses. It depends. And then we talk about the $100,000 to $200,000 profit. Once you're at that particular position, you want to look at those risk management strategies that we have. Yeah. So then the next question then really comes around, what is the advantage of setting up the various entity structures for tax planning?
Yeah, well, look, a big key there that we have our, minds on as advisors is really understanding where this business might go for capital gains tax, because if a business, look, a lot of businesses, they don't survive the first 5 years, but quite a lot of them have a transaction, within maybe the first 15 years. So that one thing I just actually can't handle as a tax advisor is if someone sells their business in the wrong structure and they cop 45% tax when it should have been tax-free under the CGT rules. It's really quite frustrating. So, and again, it's really important you're in the right structures there and you're advised, correctly. So, for example, I just use the fact that, growing one family business, before 22nd February 2022 would run under a trading trust, sell the business for, $1.5 million, all tax-free. As long as they got less than $6 million in assets, it's all tax-free, easy.
Well, the $1.5 million goes straight into their bank account. Is that right? No tax.
No tax, that's right. Yeah. Exactly.
Especially if you've got the tax advice from Pat.
Yeah, there's a little bit of complexity where they might need to put a quarter of it into super, and they can run off to Dave and ask where they want to put that. So there's a little bit there, but now, see, with these change in trust rules, it actually affects the way you sell your business when you're coming with the potential purchaser. Because if you're now going to run under a company structure, okay, and you're going to sell that business, you want to sell the shares in the company, which means you've got to get the company clean. You've got to talk to the purchaser, say, no, we want to run the shares. So the purchaser will want to do more due diligence because they're picking up the skeletons of the company. But it's important that people really understand that, because you do not want to pay capital gains tax when you don't have to, which is essentially if you've got a business running in a company structure and you sell that business in the company, within the first 15 years of the business, you're going to pay through the nose in tax. So, get the asset protection right first. But in our minds as small business advisors, the CGT event's always in our minds too, because there's often an event. It can be the sale because it's gone well, a sick child, I'm out of the business, a key employee wants to buy it. There's all sorts of reasons, but a lot of them can be gone.
But see, Pat, that goes back to your point around the seeking advice. So you stagger that advice along the way. But even that sequencing of some of that timing, if you said it was less than 15 years or over 15 years, so if someone hadn't sought appropriate advice, they may have potentially sold the business on the 30th of June, which was inside the 15-year period, versus the 1st of July, which is into the 15th year. So it's also that timing issue that some people forget. It may take you 3 to 5 years to get your structure right to do that exit, because you may have to stagger it over multiple financial years, or you may decide to delay the actual transaction for one more or a couple of financial years because of the tax saving, potentially, that sits there. And I don't look at, say, tax planning as a dirty word. To me, that's quite appropriate. Why would you not use the tax system to your benefit long term? Like, I don't have a problem with people doing appropriate tax planning. I think that's the right thing to do.
No, that's right. I mean, these rules, CGT, the reduction in the CGT for small business was put in the late 90s because it was put in by the government because people are working hard in small business. They're probably not putting a heap into their super. But the rules around small business CGT concessions, we get the structuring right at the start, but when something happens, they're very, very complex. So, Emily in our office, one of the business partners, is a tax specialist, and she deals a lot in this area. And it is very complex, and you've got to get it right. Just like you said, Dave, it can be timing. Your age can affect it, when the age of the company and your own personal age, and there's superannuation you've got to look at. So all of that, again, it's all got to be done under advice. And we've seen too many disasters over the years, where people have just set things up wrong.
Well, especially if you have a pre-85, so a CGT exempt asset, which there's still lots of them around, to get that tax planning done right can be millions of dollars in tax.
Yeah, that's exactly right. Those ones are massive. We would, for pre-85, some of those pre-85s, we'll probably need a tax lawyer. They're so complex. Go back there. Most of the small business stuff we can handle, but CGT on small business is huge, and you want to get it right, because if you develop anything, you want to protect it first, and then see if you can get obviously the best tax outcome.
And what about where you've got a business that's run by more than one family? So might be brother and sister, two families, brother and sister who are, two families, or it might be just two friends who started a business. We see a lot of that. And can I say, before you get into it, Pat, the first thing you do is you get a shareholder agreement or a partnership agreement. You get an agreement between.
We're mates, Alex. We'll be right. Yeah. We won't argue.
Yeah, I've heard a lot of that. We're mates. And you make out until someone gets divorced or someone gets sick or someone gets upset or the shits with each other or whatever. But putting that aside, if you got two families, because we talked about one family, you've got two families operating a business. Should they just be 50-50 shareholders, or should they be in a partnership, or what should they do?
Yeah, I suppose on your first point there, every single small business client we have like that, where there's another partner, you must have a signed agreement, whether it's a unit holder or shareholders agreement. We've got one of our books at the moment. It's just an absolute nightmare. They did all the preparation and it wasn't signed. It's a nightmare. So that's what you said there. It's really important that happens. And often that does coincide with the restructure. So, Alex and Dave go into business and they're going all right after a couple of years, and they're starting to make a couple $100,000 in profit. We'd sit down with them in a common law partnership. Now they've got to really protect the business, number one. They're right there, probably a unit holders agreement. We tend to advise them to go into a unit trust structure. If it's not a unit trust structure, it would be a trading company structure with each of them having a family trust owning the the shares in that trading company. Again, unit trust versus company will depend on the type of business and, what they're going to do with that business in the future. So, again, generally they'll start off common law partnership just to see if it's going to work.
Yep.
And then, restructured into either a unit trust or a company. Discretionary trusts, running businesses or owning assets are great just for one family.
Yeah, that's like personal partners, mum and dad and the kids or whatever, that one family,
That's
not
right.
a brother and a sister who are,
That's right. It's got to be unit trust or trading company.
Yeah.
But that also then comes back into the question when they start to talk about further entities, self-managed super funds, when they're starting to deal with, if it's a successful business and they're looking to purchase, real business assets. And too many times I see some people, no, we'll set it up as an individual trustee versus a corporate trustee on a self-managed super fund, and all of the issues that come around that with multiple members. And that to me is also a really big issue that's out there, that people, again, don't always think about, well, what are the risks and what's the best entity for me to operate from?
Yeah, well, that's it. Look, it's another good question. A lot of our clients want to run self-managed super funds, and quite a few of them, they can run their business in a commercial property that they own. It's awesome. I love it. Yep. So that all works well, but you cannot go with individual trustees of a self-managed super fund, because one of them kicks the bucket. You can't run a self-managed super fund on your own. So we always say to them, get a corporate trustee of your super fund, and it's all estate planning. Get the nomination forms done, which is, the wills within super, and make sure you have a corporate trustee, because one of them suddenly kicks the bucket, you can keep operating easily.
Yeah, come on, Pat. I'm not going to die. I'm fit. I'm healthy. I'm an athlete. Look at me. Seriously. And look, that's a really interesting, because people go, but it's only the old blokes that die. Hang on, you've come in the partnership or in the company structure, and you're a major shareholder or a minority shareholder. Don't just assume that the older of the partners is the one that will drop off the perch first.
Yeah, well, that we've got a horror story. That with one of our partners. One of our partners was dealing with the client, and I think in a situation like this, and he virtually saying to the client, had an extremely sick, terminally ill personal partner. I'm laughing about it, but don't turn off the machine before we do this paperwork. That's how bad it can get, and it's just silly to not get things straight. It's just inertia, but it's got to be nailed into them that once you restructure and you're getting into unit trust structures, get your estate planning right, and in self-managed super funds, get the structuring right. So it's actually not that hard. Yep. And they also need to listen to their advisors, legal advisors, financial advisors, and accountants. It's not expensive to get the advice and then just follow it. And our best clients do that. Our best clients, they ring, they follow the advice, they put in place what's supposed to be done, they do all the living estate planning and that. It's probably because they're smart.
Yeah, and again, I think that's an important. So I'm very conscious, Pat, that we've really only got you for another couple of minutes. So Alex, is there anything specific you wanted Pat to cover, or do you just want to let Pat wrap up? When we talk about structural risks, what's the best thing to operate from?
Yeah, I've got no more questions. I think Pat's answered my questions about a trust versus a company, and about one family versus two families. And and I like the quotable quote, which is, get advice and follow it.
Yeah, it's amazing that, isn't it? You get advice and go, I don't like that advice, so I'm going to go and do the complete opposite of what you just told me to do.
Yeah, that's right.
I do think, Pat, for me, the sort of, if I take a hold of a lot of the stuff that you've said to us, is that there are costs involved, and there's costs in doing anything in life, whether that be for yourself personally or within a business, but not to always look at those as a cost. That's an investment in your business. If you have a belief in that business, seek the advice, invest in getting the right advice, because the return will come on that investment, because you're not having to backtrack on different things because you were trying to be a bit cheap at the start. That can always come back and bite you in the arse, if you ask me. I've just seen it too many times. And so the importance is seek the right advice, understand what the investment is to do the appropriate advice. And as you said, it may be a staggered approach. Start at this, but be aware that once you get to this threshold, perhaps let's progress to the next stage, but continue to engage with the advice or the advisor base that you generate, because they're there to help. They're not, advisors are not around to try and destroy a business. They're there to help the business grow.
Yeah.
Well, you pay them or you pay the tax office.
Yeah.
We see it time after time after time, wrong structuring, not following advice. I just mentioned before the disaster story about the shareholders agreement that wasn't signed. Cost the client 120 grand, I reckon. 120 grand.
Yep.
And the signatures of all the agreements probably 5 to 10 grand. So I couldn't agree more. And the older I get, and I am very old.
You're as old as Alex.
It just every single one of the clients, if they just followed that basic stuff, and it is a very low cost investment for the future. Yeah.
All right. Well, we're going to close out because we know that Patty's a busy man and he's all over the place. So, again, we'd like to sort of thank Pat for his time with the discussion with Alex and myself today. So, I'd like to thank. So, we've got Pat Mannix from Paris Financial, and we have Alex today from Taurus Legal Management, and he can be contacted via LinkedIn at Alex Martin or via his website, tauruslawyers.com. I'd also like to thank myself, David Murdoch, from the Wealth Activist from Paxton Bridge, and I also can be contacted via LinkedIn at David Murdoch or via our website at Paxton Bridge. Pat, before we go, can you just pass on the best way for people to get in contact with you and the website for your business?
Yeah, thanks, David. Thanks for having me on your program, you and Alex here. So I'm Pat Mannix on LinkedIn, and just parisfinancial.com.au, and you'll see we're all into small business tax, and we're on that side.
All right, perfect. Gentlemen, thank you for your time. Bit of banter in the afternoon, we always enjoy, and I'm sure there'll be an occasion for us to get the three amigos back together. So, gentlemen.
The beginning of a very bad joke. Thanks,
there you go. We love that one. All right, everyone. Thank you, and we shall talk soon.
Okay, thanks. Cheers.